calm, controlled tone. Most people think they know what to do when a police officer tells them to step out of the car. They don't. What you've seen online is usually simplified, outdated, or completely disconnected from how courts actually evaluate these situations. Because in real cases, it's not the argument that decides the outcome. It's the seconds, the quiet, almost invisible moments where your body moves before your mind fully processes what's happening. And later, those moments are slowed down, replayed, and analyzed frame by frame. Not by the officer, but by prosecutors, defense attorneys, judges. So, this is not about confrontation. It's not about refusing. It's about understanding how your behavior is interpreted after the fact. Because that's where cases are won or lost. Section 1. The moment you become seized, here's what most people miss. The legal shift does not happen when the officer turns on the lights. It doesn't even happen when they speak. It happens the moment your body shows compliance. Courts call this submission to authority, and it changes everything. The second you reach for your seatbelt, the second your hand moves toward the door, the second your posture shifts toward exiting. That is the moment courts begin analyzing you as physically seized. Not just stopped, not just detained, seized. I've reviewed cases where no words mattered. None. The entire legal outcome depended on one silent detail. Backhand index pointing right. Did the driver begin to comply before force was used or after? Because if your body signals compliance first, force often becomes legally justified. If force comes first, the analysis shifts. Timing matters. Not what you say, not what you feel. Backhand index pointing right when your body moves. Section 2. Order versus force. Two different tracks, there's a line most people never see. But courts see it clearly. An officer giving an order and an officer using force are not the same thing. They operate on separate legal tracks. When an officer says step out of the vehicle, the law allows that order. But then something important happens. Backhand index pointing right, the law pauses. It waits. It observes your response. This is where things change. If your body remains still, if your posture suggests hesitation, if your movements create uncertainty, that pause begins to justify force. But if force comes too early, before your body shows anything that could be interpreted as resistance, that becomes a problem. Courts analyze whether force was reactive or preemptive, and that distinction often decides the case. Section 3. Body language over words. Most people focus on what they say. Courts focus on what they see. Body cam footage is visual evidence first. Audio comes second. That means your hands, your shoulders, your posture matter more than your words. You can say, "I'm cooperating" 10 times, but if your body stays rigid or your movements appear delayed, the visual record overrides the audio. Here's a real pattern I've seen repeatedly. A driver speaks calmly, uses respectful language, asks reasonable questions, but their body stays still. No movement, no visible compliance. And in court, that silence, combined with stillness, gets interpreted as refusal. Movement is communication, and courts trust it more than speech. Section 4. The door lock signal. This is one of the most overlooked details, and yet it appears again and again in case reviews. Backhand index pointing right, the door lock. When an officer gives an exit command, what happens next matters more than you think. If the door stays locked, that can be interpreted as hesitation. Not defiance, but uncertainty. And uncertainty gives officers room to justify escalation. But something subtle happens when the door unlocks. That sound, that click, becomes a timestamp. It signals readiness, not surrender, not compliance in full, but acknowledgement. I've seen cases where that single moment, the unlocking of the door, became a key part of the legal argument. Small mechanical actions often carry more weight than spoken words. Section 5. The refusal trap. This is where many people lose control of the situation without realizing it. Refusal does not require aggression. It doesn't require raised voices. It often looks like this. Backhand index pointing right, silence. Backhand index pointing right, stillness. Backhand index pointing right, delay. You ask a question. The officer repeats the command. You remain in place. From your perspective, you're thinking. From the court's perspective, backhand index pointing right, you're refusing. Because the legal system doesn't pause for your internal process. It measures observable behavior. Every second of stillness becomes part of the narrative. Every repeated command becomes evidence. And suddenly what felt like calm restraint gets reframed as noncompliance. Section 6, seatbelt timing. This detail surprises people, but it shows up often in legal analysis. The seatbelt. It's not just a safety device. It's a signal. When you unbuckle, how you unbuckle, and when you do it, all get recorded. That click, it becomes a timestamp. Unbuckled too early, it can look unpredictable. Unbuckle too late, it can look delayed. Both interpretations appear in court. That's how precise these reviews become. Even your hand movement across your body can be analyzed for intent. Not what you meant. Backhand index pointing right, what it looked like. Section 7. Body cam audio triggers. Most people think body cam is about video. It's not. Audio often carries more weight. Your breathing, your tone, your timing, all of it gets captured, and later it gets dissected. Here's something critical. If your voice overlaps with the officer's commands, it can be interpreted as disruption. Not because of what you said, but because of when you said it. Timing matters. Even silence matters. Long pauses after commands become measurable. And once those pauses extend, they begin to justify escalation. Section 8. Removal versus arrest. This confusion creates problems. Being pulled out of the car is not the same as being arrested. They feel identical, but legally they are separate. Removal is about control, positioning, safety. Arrest is about custody. And here's the key. Officers often delay arrest language because it gives them flexibility. During that window, courts allow broader physical control. So when people say, "Am I under arrest?" it doesn't change the legal status, because status isn't defined by your question. It's defined by their actions. Section 9. Rights change. After you exit, this is where most people get caught off guard. Inside the car, you are contained. Once you step out, everything changes. The environment opens. The officer gains movement, positioning, control. Courts recognize this shift, and they allow more physical direction. Your speech matters less. Your posture matters more. Where you stand, how you move, where your hands are, becomes the primary focus. This is no longer a conversation. It's a positioning phase. OUTRO, slow, impactful tone. Every moment we just covered is something most people never think about. Until it's too late. Because the reality is this, you are not judged in real time. You are judged later. In slow motion. In silence. With every movement analyzed, every second measured, and every action interpreted. Not based on what you meant. Backhand index pointing, right? But based on what it looked like. So, the goal isn't to argue. It isn't to outsmart. It's to remain clear, predictable, observable. Because clarity survives review. Confusion does not.